Nathaniel Warmbier. Is Mr. Warmbier's motion to set aside or amend or improper order and strike your attorney's fees. He's filed it.
Yes, Your Honor.
Representing himself pro se.
Yes, Your Honor. Apparently a chat GPT or AI aficionado that he has filed this pro se.
So you're saying this is artificially intelligently drawn?
Yes, Your Honor. And Your Honor, we would proceed with, and again, just for the court to make a record, Mr. Warmbier filed this petition under Rule 11 of Tennessee Rules of Civil Procedure, as well as, and filed a Rule 11 motion, as well as the motion to set aside, alleging that I had made false claims to the court. He additionally has attempted and requested copy of the transcript of the proceedings. He did not share in the per diem. I offered for him to purchase the transcript. He is under the obvious inappropriate opinion that I have an obligation to give it to him, that's a matter of public record. So in addressing his issues, Your Honor, I would refer, Your Honor, to the hearing that took place on May 28th of 2025, wherein we proceeded on a petition to establish paternity and to adopt a parenting plan after discovery and things back and forth. Mr. Warmbier appeared, and during his opening, he was pro se, and during his opening arguments, he made a number of statements, which included making admissions that he had failed to pay child support. On that day, I had also served him with a petition for contempt out of juvenile court where his child support matter is pending. At the inception of the hearing, I called him as my first witness, and I asked him to be sworn in. At the time he was sworn in, and I asked him, Mr. Warmbier, do you understand that you're under oath? Yes, ma'am. When you were giving your opening argument to the judge, you were not under oath. Okay. So that you now understand that you're sworn to tell the truth. That's correct. The answer is that's correct. And you understand that the statements that you made before the court in your opening arguments, will you affirm that all those were true? Yes, I would like to. So I don't commit perjury. December of last year, I was allowed to visit the children for 30 to 45 minutes. That was the only time that I saw the children. It was something that I did forget to mention in opening statement. Other than that, all else remains true. Question, so you're admitting that you were significantly behind in child support? Yes, ma'am. You are admitting that you knew willfully, that you are willfully behind in child support, that you knew you owed that obligation, correct? Yes. And that you used the child support as a weapon, basically, against Miss Whitworth to try to get some type of agreement on visitation, is that correct? Weapon is a strong word. Well, what word are you going to use? I'm sticking with leverage. Question, leverage, okay. But you're stating under oath that you willfully withheld paying child support and that you used it as leverage against Miss Whitworth, correct? I did, yes. And you understand you were served with a petition for contempt of court for failing to pay child support? Yes. Did you have an opportunity to read that petition? I was able to glance over it. And you understand the statements before this court, there's a court reporter, and everything that you say under oath has been true and correct? Yes. We then proceeded and had a hearing wherein I called my client, Mrs. Whitworth, who put on testimony. And then Mr. Warmbier then stood up before the court. Your Honor, after hearing what was just stated, I told him to go up to the podium. Oh, I'm sorry. And he said, I was taking those moments as a reflective period. A lot of what she read out, that was very true. I said some nasty, heinous things. I didn't do right. I'm willing to accept the proposal that they're given, that we can. And you said, all right, Ms. Roberts, it appears he's willing to accept your proposal. So if you're willing to submit your proposal in written form, then we'll go from there. Thank you, Your Honor. And so what I did, Your Honor, is I prepared an order from the 28th day of May of 2025. And I stated in there that Mr. Warmbier was appearing pro se at the conclusion of the testimony and other proof offered by the plaintiff in her case in chief. The respondent, after being duly sworn, announced that he acknowledged that his behavior had not been in the children's best interest and that he agreed and stipulated on the record that the permanent parenting plan offered by the petitioner was in the best interest of the minor children. Respondent further acknowledged under oath that he failed to make timely payments of his support obligation and that he had the ability to make such payments and withheld paying the funds to the petitioner in retaliation of her not complying with his demands. He testified that his actions were not appropriate and he regretted his actions. Based on the proof and stipulation, the court finds the plan tendered by the petitioner mother in the children's best interest. I adopted the plan and I entered a judgment because he consented, and I asked for attorney's fees. I charged Ms. Whitworth a flat fee of $5,000 and I entered a judgment for that $5,000. And that's the order that he is attempting to set aside and state that I made false claims and asked for Rule 11 sanctions against me. And I would ask that the court make an affirmative finding that the order is true and correct and that the Rule 11 sanction is not inappropriate.
I'm familiar with the proceedings that took place in this case, and I signed the order because I thought that the order affirmatively reflected the announcement that was made that day and the evidence that was offered at the trial. And for that reason, I find that the order that was entered and the one that Mr. Warmbier is seeking to overturn is the appropriate order, and that his motion is not well taken, and that there was no violation of Rule 11 sanctions. If any violation of Rule 11 occurred, it was by Mr. Warmbier rather than Ms. Roberts. So Mr. Warmbier's motion is denied, and you may draft an order accordingly.
Thank you, Your Honor.
This is a show cause order to both of the parents for failing to provide the court with proof of their completion of a parenting class as required under the parenting plan that was entered in the case, and the order will be entered in the court file reflecting that neither of them has complied, and that will be considered by the court in any future litigation.
This was a petition to modify, and we obtained a ex parte restraining order. We have been able to resolve the whole matter by the order that you're signing, so the ex parte restraining order will dissolve as of today, and that order, the new order will remain in effect.
All right, I have signed your agreed order.
Thank you, Your Honor.
Thank you.
Thank you, Judge. Thank you.
Ms. Perricone is here on Zoom. The first issue is that Ms. Perricone had filed a motion to be allowed to testify in this proceeding via remotely by audiovisual means, and she filed that under Rule 43.01 of the Tennessee Rules of Civil Procedure. So I need to first address that issue because obviously these are substantive motions that she's filed, and then you have also filed a substantive motion, and the court needs to address whether or not she's going to be allowed to present testimony and so forth under Rule 43.01, or whether or not she's going to have to appear in person. So if you allow me to let Ms. Perricone go ahead and make that statement. Let me first observe, Ms. Perricone, that your motion that was set yesterday, there was some confusion about it. I have reviewed your motion to allow you to testify remotely under 43.01, and I'm willing to let you tell me why you feel that it's necessary for you to appear under those conditions.
Thank you, Your Honor. Yesterday I was present at 9 and then 10:30, so I do appreciate you giving me the chance to speak. It's a hardship just due to the distance and the short amount of time there, and obviously having a 3-year-old, and it would be obviously very much appreciated if I could appear remotely. I can obviously have a quiet place just like I do now and make sure that all of the rules are followed. So that's pretty much what I have to state on that.
Well, first of all, let me tell you that if you had reviewed the rule that you had filed your motion under 43.01, a motion for permission to present testimony by audio-visual means must be filed at least 60 days before the hearing or trial which the party seeks permission to present testimony. And that gives any party, such as Mr. Davis and Mr. Baker, the right under that rule to object in writing 10 days after the service of the notice of the motion. Your motion was filed according to our court file, it was filed last Friday, the 12th, and therefore it doesn't comply with the time limit that the rule provides. Second is, and this is more salient, the motions that you have filed or have been filed on your behalf allege various procedural defaults and constitutional claims arising from different issues that you claim, which are at length citing various constitutional issues and, for example, declaratory claims under Tennessee Code annotated 36.8, so forth. A verified motion to enjoin unilateral medical decisions, preserve the children's religious and constitutional rights. Motion for reconsideration of an order granting the respondent's motion to compel. A motion for dismissal of our guardian ad litem. Who is the guardian ad litem?
Miss Furlong Smith, and she's on a Zoom just outside the courtroom. I think she'll be in shortly.
Okay.
Judge, with the court's permission, Ms. Smith, she is on the Zoom call in another matter.
All right.
So with the court's permission, I'll be taking that.
All right, and my point of that is that under that rule that you have cited, under there's an order for remote testimony by audiovisual transmission. The court may enter an order permitting the presentation of testimony by audiovisual means as follows. For non-party or lay witnesses, upon a finding that good cause exists for accepting the testimony of audiovisual transmission. That's a very low burden, just requires good cause. However, where it's a party or an expert witness, upon a finding that with due regard for the importance of presenting testimony through witnesses physically present in the courtroom, exceptional circumstances warrant receiving the testimony of a party or expert witness by audiovisual transmission in the interest of justice. And in this case, based on all of the allegations that have been made, and my review of the various pleadings that you have filed leads me to question whether or not these pleadings are actually drafted by you or by some other person, and whether or not they represent your own personal argument, or if you are utilizing some other person, either an artificial intelligence or something else. And for those reasons, I have considered your request to testify remotely, and I must deny your request. In view of that fact, I will allow you to reschedule your motions to be heard when you can actually appear in the state of Tennessee, rather than take them up because you cannot present your testimony remotely. That would be my ruling in this matter as far as her motion goes. And in fairness to Ms. Perricone, I would give her an opportunity to be present. Again, we can reset these motions for October the 27th. Is that the day I gave you?
Therein lies the rub, Your Honor. Let's see.
Well, I have another day. No, that is the next Chancery Day after this month, right?
I am unavailable on.
You are?
Unavailable on the 27th. I'll be in depositions that day.
What about the 31st, Halloween?
How fitting. I'll be here with costume and all.
All right, Ms. Perricone, I can reset all of these for October the 31st to give you ample time to make your to travel here for the court appearance, okay?
Okay, thank you, Your Honor.
Everything will be reset for that day, October 31st.
Yeah, maybe we should check with the GAO real quick, Your Honor. She may have a costume party to attend.
The guardian ad litem stand-in was uncharacteristically quiet at the moment, so I have forgotten.
She was doing her best Mickey Furlong Smith impression. And just to clarify, that includes Father's Rule 11 motion.
Yes.
As well. Okay.
Your motion's to dismiss and Rule 11, under Rule 11.
Thank you, Your Honor. I'll get out of here before the court appoints me to a case.
Do what?
I'm gonna get out of here before you appoint me to another
Well,
case.
let's don't leave too quickly, because we got to make sure that, and we had criminal mixed in with civil yesterday, Mr. Davis. We could have given you some more work if you wanted. Ms. Perricone has exited our hearing. I'm going to set it for October the 31st. All right, then we are good to go on October 31st.
Forum for a review of an ex parte restraining order that was entered, as well as a hearing on a modification.
All right. Now, I show it's for a final hearing in addition to the review of the ex parte. So you may call your first witness. All right. And this, are we having this child testify in open court, or are we going to do it in chambers? I prefer not to hear from children, period, put them in the middle, but I also know that factually sometimes there's no way around that. And the other preference I have is that if we're going to hear from children, we do it in the chambers across the hallway from the jury room, but that would depend on if both sides agree on that. So, Mr. Baker, do you have any opposition to having a child testify in chambers? Both the lawyers will be present. All right, then we'll bring the child in and have her testify. We're going to go across the hallway and we'll hear from her in chambers. All right, counsel.
Judge, I think after we've discussed with our clients, extend the TRO as to the oldest child. Eval.
You say December? Well, let me say this to the parties. Your daughter is obviously, I hate hearing from children in chambers. That's one of the things I hate the most, but sometimes it's a necessary thing. But your daughter has been very emotional this morning when she talked with me and described some of the issues that she saw. Clearly, we can continue with the hearing, but I think it's wise that your lawyers have arrived at the agreement that pretty much mimics what I was going to do, at least where I was in my thinking. And that is, there's been some allegation of drug use, so we're going to order that both of you submit to a hair follicle extended panel, what you want, pardon me, an extended panel hair follicle test. And then we're going to appoint a guardian ad litem for the benefit of your children, because you have 3 children, if I'm understanding correctly, and the oldest child has pretty strong, preferences to what she wants. The other 2 are below the age where the court is required to consider their wishes. But I also hesitate to separate children, but we are going to go ahead and continue that the daughter will remain with the father, and the other 2 children will resume their week on, week off with the mom until we can get something else done. So let's appoint, who do you have in mind to appoint the guardian ad litem? Ms. Smith is, I just don't know that she's covered up, but if she has the availability, she would be my preference, but you have someone else in mind? Lynn Coffenberry is often, let's appoint Lynn Coffenberry, who is probably a little more available. She'll be the guardian ad litem. The Rule 35 evaluation is based upon the fact that the pleadings in this case and the testimony that I've heard indicate that there's a cause for concern regarding the behavior, at least of the mom, and so we want to go ahead and eliminate any issues that might result from that, and we'll have a Rule 35 evaluation to make sure there's no outstanding issues, and then from that, having appointed a guardian ad litem, and I would think that if nothing else, we need to start family counseling for all of the children, but also especially with the mom and this oldest daughter, because there are some issues. And it's not unusual for Amber to have some issues where she's going back and forth and she likes one house more than the other. I just want to make sure there's not something else more pressing that would be an issue. And with that being the case, looking at the month of December when you're talking about setting it, did I give you any December dates? The what? I have criminal trials. How about the 5th of December? That's Judge Turnbow, which you want him to hear the case, that's fine too. But she wants December the 5th for a chancery day. So.
Looks like a good day.
All right.
We can make 12/5 work, sure.
December the 5th will now be a Dixon Chancery Day, and you can set this case on the docket for review. It's hard to raise children when you're divorced and you're going back, and they go back and forth. It really requires for this equal residential schedule to work, parties to communicate as well as possible. Sometimes that's not possible when parties have gone through a divorce or a child custody situation in the past. I hope whatever the problem has been will be alleviated by the counseling and the things that we're doing here today, and that the children need both of you in their lives. Right now, Amber is upset and she wants to stay primarily with her dad, but as a practical matter, she also wants to see you and to have an opportunity to do that. And I think that counseling with you and her can help overcome a lot of those issues. So the ideal situation is, let's make sure we're not talking, and this order needs to contain a prohibition against either of them making derogatory remarks to the children about the other parent, or if there are significant others in the other, if you have someone in your life and you've remarried, right? Then let's include that to prohibit any negative remarks about the other significant others in the parents' lives. So, anything else we need to address?
Oh, Your Honor. No, I think that's it.
Who's drawing the order?
Be glad to.
All right.
I'll circulate it, make sure everything's,
Thank you.
thank you, Your Honor.
All right, that concludes our business for today then, and we stand adjourned.